Welcome everyone to, I think we only had 2 so far this term, IP seminars, but there are more to come. In fact, one of our special guests from CIP, Annette Kuh, is in the audience, who is going to give a talk at some point later, hopefully, Annette, yeah?
If we find a date.
I think we will find a date once you have your... But having said that, this time we have Xavier Seuba. Xavier is essentially, I think, a public international law scholar who has come to IP at some point. Fairly long in the past, because you've been doing IP for many, many years. And Xavier has been involved quite a lot, even without me reading this or here. I remember Xavier has done a lot on international health law, public health and IP interfaces. He's done a lot on IP enforcement. He's advised Latin American governments in their negotiations with the EU on free trade agreements. So he's done a lot on FTAs, but he does a lot on enforcement as well. And I don't think I need to say much more. So Xavier, the floor is yours, and we'll be happy to hear from you. Thank you.
Thank you very much, Henning. Thank you very much for this kind invitation to deliver this talk. And with Henning, we meet once again here and there in a small academic meetings, but this occasion is particularly nice because visiting Cambridge, visiting you it's a very nice opportunity. So thank you very much for the invitation again. And what I will try to do in this presentation is to present the overall picture of preferential trade agreements promoted by the European Union and the intellectual property content in these preferential trade agreements, mixing the two aspects that Henning was commenting on my profile. I have worked for some international organizations and some national governments. I'm a scholar, that's at least I consider myself being a scholar, but I mix quite often both activities, and I participate in some of the negotiations. Now I'm involved in the Mercosur and the European Union negotiations, before in the Peru and Colombia negotiations, and in some other. No? And I think that this presentation will be a compromise between the two, I would say, aspects of my CV. And it could be very broad, because these intellectual property chapters of free trade agreements are a sort of mini intellectual property codes. So we could find trademarks, patents, copyrights, enforcement, everything is there. So I will try to synthesize, to present the main trends, and probably in the questions and answers there will be more specific aspects that you may want to raise. Okay? So the relationship between trade agreements and intellectual property is new, but the regulation of trade by means of trade agreements obviously is not so new. In the 19th century, in the 1840s, there was a revolution of trade agreements. I think that about 15 years, more than 50 agreements were negotiated. Always the UK was there. The reduction of tariff cuts was followed by the adoption of new trade agreements. But by that time, IP obviously was not a trade-related issue. Probably it was the other way around. By that time, intellectual property was more perceived as a trade-restrictive kind of measure. And this tension between intellectual property and trade has continued to manifest in the text of present international agreements with intellectual property chapters. It is quite often, from the treaty agreement to bilateral trade agreements, that you will find a provision saying that the protection of intellectual property should not limit or constrain legitimate trade. So this tension is an echo of something that was already identified in the 19th century. And last years, I want to say the last 2 decades, what we have seen is a booming of the conclusion of free trade agreements. Nowadays, in 2019, so January 2019, the World Trade Organization reports that about 67 free trade agreements have been notified. And this increase in the number of free trade agreements that have been notified to the World Trade Organization, it is noteworthy to underline that most of them have been adopted in the last 20 years. When the World Trade Organization was created in 1995, only 30 free trade agreements existed and were in force. In between that year and now, we have these more than 430 new free trade agreements. And some of them cover intellectual property, some others do not cover intellectual property. But the phenomenon that it is remarkable is that more and more, many of them include intellectual property. What you have here is a graph. It's a graph showing the number of free trade agreements that include intellectual property chapters that are meaningful, that have substantive provisions, meaningful provisions on IP that enter into force annually. And you can see that every year, in between 6 and 14 free trade agreements regulating intellectual property enter into force. This has resulted in a number of, nowadays, about 160 free trade agreements regulating intellectual property. Again, the phenomenon is particularly interesting because if you think in international terms, probably these trade agreements are the major source of international intellectual property regulation in terms of numbers. Obviously, you have multilateral agreements, plurilateral agreements, but in terms of numbers, free trade agreements have become the major source of intellectual property regulation. So, the big question here, and the question that we should pose ourselves, is why we continue calling these agreements free trade agreements, when in reality, like intellectual property, there are many other areas that are covered under the many chapters that these agreements include. If you see the content, if you just read the index of the agreements, you will see that you can find there the regulation of services, regulation of investment, the regulation of subsidies, intellectual property, obviously, and so on and so forth. So in reality, what we have are sort of international harmonization economic agreements, more than free trade agreements. Just to put you an example, the negotiations between the European Union and the United States for the TTIP that were stopped with the President Trump, the decision of President Trump 1 year and a half ago to stop these negotiations, the benefits for US pharma producers resulting from regulatory harmonization multiplied per 10 the benefits that they will obtain in tariff reductions. So the big advantage there was in the regulatory chapter, not in the tariff cuts chapter. And the same applies for intellectual property. Imagine the situation, the very frequent situation, of countries that have very different standards of protection, negotiating a free trade agreement between, let's say, Costa Rica and the European Union, where the different levels of protection are really important. The change in the regulation for Costa Rica is going to imply a large amount, let's say, of money for right holders in this particular case. So the benefits, the real benefits, or the meaningful economic effects of these agreements are found elsewhere, or not only in the tariff chapters of these agreements. What you have here is the map of the relations, trade relations of the European Union. More or less, to simplify things, you can see that in red and in orange, you have the agreements that are already ongoing between the European Union and the trade partners. Some of them have some dots, yellow dots. Mexico, for instance, these were negotiations that were undergoing when this map was drawn, but this has already been finished. And these red and orange countries are those that already subscribed meaningful trade agreements with the European Union. What it is remarkable here is that in yellow you have ongoing negotiations. So presently the European Union is negotiating with Mercosur, with Australia, with India. Well, India negotiations apparently are stopped, but you have others like Indonesia. So you can see that there is a lot ongoing, and that the entire map of trade relations of the European Union has already changed, and probably will change even more in face of the, let's say, the crisis that multilateralism is undergoing. In the trade agreements that the EU negotiates, you can see this here, we have different levels of intellectual property protection. What I did in this table was to classify the different agreements according to the content, the intellectual property content provided therein. We can at least identify 3 different generations of preferential trade agreements with intellectual property provisions, depending on the substantive content they include. And the logic of this table is found in the chronological order. The more or the newer the agreement, the more content, the more sophisticated the content of the treaty is. So you can see that in the 70s and early 90s, there were agreements, first generation, that intellectual property was not an issue there. Sometimes there was a reference to intellectual property protection, but very minor one. Instead, in the early 2000s, there was a number of agreements where the importance of intellectual property was already underlined, was already put in the text of the agreement, and some intellectual property provisions, some intellectual property areas started to receive attention. Mostly, this was the case of border measures and intellectual property. But still, the content was quite marginal, we could say. Then, and this was not by chance, but it was the outcome of a political decision, a policy decision of the Commission, after 2004, when the strategy for the enforcement of IP rights of the European Union was passed, intellectual property in free trade agreements became an objective of the EU. And you start to negotiate in 2005, 2006, and the outcome, the first results, start to manifest in 2007, 2008. And in these agreements, the agreement with CARIFORUM, with Central America, the agreement that was negotiated, but well, it took some time to enter into force, with Ecuador, Colombia, and Peru, are the result of this decision of the Commission to really include intellectual property in a meaningful way in these IP chapters of trade agreements. This was a copy, this was just following up what the US was already doing before the EU. So the EU followed the steps of the US in that particular sense. So you could group, or we could group, all these agreements in a third generation group of agreements with sophisticated IP clauses, with IP chapters that go through all IP categories, enforcement mechanism, and so on and so forth. And there is a new set of trade agreements with really sophisticated provisions that include countries as important as Japan, Canada, Mexico, Singapore, where really the intellectual property chapter is a sophisticated one, ambitious one. In parallel to these generations, there is this group in red, your right hand, of countries that for different reasons, probably because some of them are countries that would like to accede to the EU, where the provision that you will have is a single one, but a very powerful one, saying that these countries have to respect the same level of intellectual property protection to that one existing in the European Union. So you could not say more than that, okay, in terms of ambition. Nowadays, so right now, when you have our ongoing negotiations with Chile to renew the trade agreement and the IP chapter that already existed, but it will go far beyond to what we already know. And these ongoing negotiations with Mercosur, there was a round last December. Let's see what happens there. These are political negotiations, not only technical negotiations. And you have these other negotiations with Indonesia. India seems to have pulled the brake there. And there are other negotiations that are ongoing but are really slow. Philippines, Burma, Morocco, Tunisia. And there are others that have been stopped. Important ones, such as the TTIP, that have been stopped for political reasons. Okay. So these treaties, even if these are legal texts, international treaties, in reality are just one among the tools that the EU has in order to promote the protection of intellectual property rights in other countries. This is clearly identified in the strategy for the enforcement of IP rights in third countries, not the one adopted in 2004, but in the one adopted in 2014. In this strategy, the EU Commission said, well, among the measures that we will implement, there is norm setting initiatives, there is also the control of already existing norms, and there is also another group of measures, soft, let's say, policy measures, that are based on the provision of technical assistance, the political dialogue, the, let's say, incentives to, to increase the level of respect of intellectual property rights. But the reality, as how things work, is that these two or these three groups of initiatives are or run in parallel. For instance, when the negotiations have been conducted between, let's say, Mercosur countries and the EU, then the Commission sends or opens a new, let's say, initiative. I don't know if you are familiar with IPK. IPK is an initiative that has been ongoing in China for some years now. Well, the EU has done the same in Latin American countries to, again, enforce or to help to enforce the provisions on intellectual property set forth in these trade agreements. So all these initiatives are working in parallel. So what I will try to do now is in three groups or in three different blocks underline the main characteristics of these trade agreements. Some of them for you are very well known: the strengthening of IP standards, the harmonization of intellectual property law, and another one that I will add is that is not so critical, just to put it in this way, but that I think that is also something that is happening and is a positive consequence of these IP chapters in preferential trade agreements. The fact that these agreements or these IP chapters in these agreements are negotiated and are concluded in order to strengthen intellectual property standards is a truism. It's something that is given for granted. And it is not a secret. So the Commission in the strategies has announced that. The treaties themselves clarify and announce that the purpose of the agreement is to reach the highest levels of international protection of intellectual property rights, and even the political statements that accompany all this always say that, well, the purpose is obviously to go beyond WTO. Okay? So there is nothing hidden there. Right? There is nothing hidden there, even if the debate sometimes presents these agreements as something that, well, it is not clear what they want. No, it's very clear, and it's announced that what they want is to have higher standards of protection. One of the areas that has attracted most controversy, one among others, but one of the areas that has attracted most controversy is that relating to patents and the protection of public health. It's not exactly the same what you will find in US and EU agreements. What they have identified here are provisions that are found in EU agreements that input the protection of public health, and that essentially focus on, first, the extension of the term of protection of not patents, either by means of the granting of supplementary protection certificates or something similar to supplementary protection certificates, or just by extending patents in the same way that the US will do. Okay? That's the first important provision that you will find in these agreements. The second one is the obligation to provide patents for second uses of already known products. Next to that, and probably even more important, is the protection granted to test data that generic manufacturers present to, that originators present to health authorities. This type of information that refers to clinical safety, efficacy, and the quality of the product, according to the treaty agreement, should be protected against unfair competition. Whether this means that you have to grant temporary protection by not allowing others to register their products or not is a matter that has not been decided at international level. What the EU does, as the US has done before, is to identify that the right way to implement that obligation is granting exclusivity to that type of information. This means that generic producers have to wait 5 years, 6 years. In reality, the standard that the EU is promoting is 6 years of protection before authorizing a generic producers to obtain marketing authorization for that particular generic product. Okay? And also other types of, this is not found in all agreements, but in some agreements also the exclusion of the principle of international exhaustion of intellectual property rights and the promotion or the preference for regional or national, well, for the US, for the EU, the regional exhaustion of IP rights. This is as far as patents and health are concerned, but other areas such as copyright and trademarks are also affected. Very simply, but you will find there is common in both areas in the sense that first you have the obligation to subscribe new treaties that were not, that the parties were not members to those treaties yet. In the Mexico Agreement, this is found in the Mexico Agreement, for instance, very recent one, 2018 one, treaties, so the treaties that they have to conclude is the Beijing Treaty on audiovisual performances and the Marrakesh Treaty for the blind and visually impaired or otherwise print disabled people. So this is one aspect, new treaties. In the trademark domain is the same with the Protocol to a Madrid Agreement and the Nice Agreement on the classification. So in both sectors, new treaties have to be subscribed. Something that is interesting is that if you compare the Mexico and the Japanese agreement, which have been concluded very recently in both cases or in parallel, you will see that in some cases the Mexico agreement goes beyond to the Japanese agreement. For instance, in terms of the protection of copyright for performers, in the Mexico agreement, this protection goes up until 75 years. Whereas for the Japanese agreement, this protection stays in 50 years. Okay? So this is something that is also striking, no? That the countries sometimes are not differentiated according to the level of development, but well, whether the EU is able to convince them to adopt specific provisions, even if they are not adjusted to their national level of development or interest. Well, another area, because it's not everything about substantive standards of protection, patents, copyrights, trademarks, enforcement. Enforcement is also, probably, at least at the beginning, was the focus of the EU when negotiating these trade agreements. A very clear case in point that Henning knows very, very well is border enforcement. In border enforcement, I would say that you have at least three main areas of contention. So what types of IP have to be controlled in customs, what custom situations are the object of control, and what is the law that will apply to the products that are object of customs control. If you take EU agreements, you will see that we move from the control of counterfeit and pirate products that you find in the TRIPS agreement to the control of almost all IP types. This is something that does not apply in all treaties, but in treaties that you will not expect, such as the CARIFORUM agreement, you will see that countries compromise to control a large number of intellectual property types. Second, in the TRIPS agreement, you are only obliged, so members of the World Trade Organization have only the obligation to control imports. In these trade agreements, you move from imports to exports and also products in or under suspensive procedures, essentially the transit or transshipment of products. Okay? So again, we enlarge the activities, we increase the number of activities that customs officials will have to take care of. And something important is also, or relates to, the law that will apply to determine the infringing status of goods. In the TRIPS agreement, when Article 52, I think, is the one that relates this, says, well, you have to control importation and you will apply the law of the country of importation. What happens with products in transit? Well, this is not clear. Note 13 says that there is no obligation to control the transit. But then, which is the law that you should take into account if you decide to control the transit? free trade agreements promoted by the EU say that this will be the law of the country of customs procedures. This means, in the sense, that if, let's say, France or the UK now is the country applying these customs procedures, the law that will be applicable is the French or the UK law. In Switzerland, for instance, they do this differently. If they control the transit, the law that they will take into account is the law of the country of importation. This gives place to other type of problems, but you know, there is this principle of territoriality and the risks that the control of goods in transit implies because of the contradiction with this principle of territoriality. And something that is also very relevant and is a feature that cuts across all these treaties is that the guarantees that you will find in defense or that will benefit the alleged infringer, the owner of the goods, the consignee, and will not be present in this free trade agreement. So in the TRIPS agreement, you have a quite detailed number of provisions regulating the, let's say, the guarantees for the alleged infringer. All these, and it's the same for the regulation on border measures, all these guarantees are absent in these chapters or in these articles on border measures that you will find in free trade agreements. Well, this is the first group of topics. No? We increase the level of protection. The second group of topics is this, the will to harmonize the type of protection that, or the standards of protection that are guaranteed in these preferential trade agreements. The idea is that the more similar to the EU law, the law of the trade partners, the better. Okay? And this is something that the US has also pursued. So both, at the same time, try to export their IP law. Again, the idea is that the IP law of the EU and the US is good, and as it is good for them, it should be good for the others. But there are some, and you will see, there is a lack of consistency in this approach, as I will try to argue right now. This is, again, not something that is hidden. There are public statements saying we want our trade partners to adopt our IP legislation. And this is also something that you find in the very same text of the agreements. The phenomenon is very well known, this transplantation of the law. And this transplantation of the law in the area of IP has functioned very, very well. Now you can go to the Republic of Korea or you can go to Peru and you will find excerpts that have been copy-pasted from the SPC regulation, from the border measure regulation, from the trademark regulation, the directive on enforcement of IP rights, and so on and so forth. So this transplantation has really worked in at least literal terms. However, these legal transplants are not, so not everyone thinks that legal transplants are good per se. In reality, the doctrine, and this has been a debate in comparative law, the doctrine in general, I will say, is quite reluctant to transplants per se. For some, and I will say that Watson was the one that promoted this more forcefully, he just said, well, transplants are just a legal, another method to codify the law, to develop the law, and it's a neutral one, okay? End of story. There are others that say, well, these are not legal transplants, and Teubner, for instance, called these imports of law coming from other countries, not legal transplant, but legal irritants, because he claims that if the situation, if the environment is different, transplanting the same law that has worked in the EU may not be the most, let's say, safe and opportune option for a country with very different situations. The problem is not only with transplants, whether they are good or bad. So if you say, let's transplant the entire directive on enforcement of IP rights, well, you can say this is good or this is bad. The problem is with the type of transplantation that has been promoted, which is a partial transplantation. What you will find in these agreements are most of the times the provisions of EU IP law that benefit right holders, that will protect right holders. Nothing bad with that. But the problem is found that all the other provisions that try to gain or regain the balance and protect the other party are absent there. What you have here is just one example, the example on interim injunctions. What you have on the right side of the slide are all the guarantees that you will find in the Directive for the Enforcement of IP Rights, and these guarantees relate to, well, the classic standards of fumus boni juris, the periculum in mora, the obligation to provide guarantee, the revocation of the measure if proceedings on the merits of the case do not start, all these type of guarantees that interim injunctions in the EU and in EU comparative patent law you will always find. But this is not present in the EU proposal to these countries, and this is general. In all the proposals, this has slightly improved in the most recent agreements, but still many of the guarantees are not there. So, what's the purpose of proposing something that comes from your legislation, but only proposing half of your legislation? This is an open question that in reality does not seem really, I would say, meaningful in practical effects, because there are several ways to overcome this problem. But in terms of image and in terms of the feeling that I would say that the EU Commission transmits when they propose this type of provisions is not really convincing, to say the least. And this is what I was saying before, that if you compare agreements concluded between countries such as Mexico or CARIFORUM or Central American countries with the agreements concluded by Canada, Japan, or the Republic of Korea, you'll see that quite often these other agreements, the agreements concluded with economic developed countries, are more balanced and are richer than the former. Okay? So again, here there is something that it seems to me has not been or is not being correctly done. But this criticism, so these were the first two blocks, we increase the levels of protection, we try to harmonize the same type of protection, to provide the same type of norms, but these aspects, these more critical aspects, can be complemented with a more, I would say, positive effect of these IP provisions of trade agreements. Countries negotiating with the EU or with the US can take advantage of these agreements in order to modernize their own intellectual property institutions and in order to include, to reflect about their IP law and to modernize their IP law in a way that eventually some missing balance that they had before or that they could include is now included. And I will put you a couple examples. In the new, I would say the third generation agreements has become a standard clause and sometimes a quite ambitious standard clause, the provision of a couple of articles, quite long sometimes, on the principles and objectives of the IP chapter. Very much like with the Article 7 and 8 of the Treaty Agreement, where you will find an enumeration of public policy goals, such as the promotion of public health, technology transfer, access to knowledge, the benefits of users, and the balance of rights and obligations. This type of provisions. But I'm just numbering the titles. These provisions are becoming more and more detailed and longer. These you could sing well, but these are just rhetoric, or let's say, yes, they are nice, but what's the practical effect of that? Well, when it comes to national implementation, and you have to think that these agreements then they have to be transposed to the national law, these articles can have a very important impact when implementing national laws that include the obligations of the IP chapter, and also for judges passing sentences relating to the provisions that are found in these trade agreements. In some particular cases, and I can name at least the case of Chile, the reforms that were undertaken to adjust the national law to the requirements that are found in the EU and the US Free Trade Agreement gave place to the introduction not only of increased levels of protection, but also of flexibilities that are found in other legislations. And I have in mind particularly the polar exception, the international exhaustion of IP rights, and, for instance, the patent exclusion of the protection of human and animal health and life. In other occasions, the negotiations have been the instrument to set up a coordination committee in the countries negotiating with the EU, an interministerial negotiating committee. And this IP committee, that includes representatives from the ministries of agriculture, health, science and technology, industry, and so on and so forth, has not only participated in the negotiations, discussing the content of the agreement and trying to find better options, but also has continued afterwards. And this has been the case of countries such as Peru and Colombia, but also the Dominican Republic. And something that have also been improved is the transparency of their IP provisions. The overall conclusion for some of the negotiators was that this process has helped us to see where we were. Sometimes we did not even know what was our level of protection. And I can tell you an anecdote. For the negotiations between Peru and Colombia, there was a huge resistance to the provision of the possibility of controlling the transit of trademark protected goods. And, negotiators just called people in the customs authority, and they said, no, but we are already doing this. It is not something new. So sometimes this type of mismatch between what some ministries are doing and what others know that is or should be done has been corrected in the process of negotiating these trade agreements. But there is something that it is not so, well known, that there is also an impact at the EU level. Obviously, we could, or the Commission will never accept that what is found in these trade agreements is going to change the EU law. In principle, the standard we negotiate is our standard, and we are not going to go beyond to what is already in EU law because our mandate is that. But what you can see is that, for instance, the recently approved manufacture for export waiver in the context of the SPC regulation is already included in the agreement between Canada and the European Union. There is no obligation there for the EU to adopt this waiver, but there is already an advancement in a direction that the EU has followed afterwards. The same can be said in respect to the exception to test data. A problem that happens, or that may eventually happen, is that if a country decides to grant a compulsory license on a patent-protected product, there is still the protection awarded by test data. And this protection, in principle, the regulations and directives that we have in the EU does not foresee an exception to waive test data protection. By contrast, in these agreements, in some of the agreements concluded by the EU, there is already a mention, a reference to the exception that can be put in place if a compulsory license is awarded in the case of pharmaceutical products, and this exception will allow to grant authorization even if test data protection is still in force. So these overlapping protections, patents and test data, will not derail, will not impede the award of market authorization to a generic producer. And something also interesting, when negotiating the Colombia and EU agreement, there was a proposal that came from an NGO saying, well, why not replicating Article 44.2 of Treaty Agreement, which says that, look, even if you grant a permanent injunction, it should be possible to substitute this permanent injunction by adequate compensation. This is very much like the eBay case, no? This type of something that happens in the US, but in principle in the EU was not the common practice. And the EU did not oppose to this, okay? And this is in the text of the EU and Colombia free trade agreement. Now, in the negotiations between the EU and Mercosur, something that we have proposed is that the entire list of exceptions that you find in the text of the agreement on the Unified Patent Court, where you will find 11 or 12 different exceptions, is the longest list of patent exceptions, is also present in that in the text of the draft agreement, and it's not a numerous clauses list. It's just an example, a list that exemplifies the type of exceptions that could be present. So, all in all, what I wanted to underline, or at least to point out, is that, well, there are also novelties for the EU. It is not only for these emerging and developing economies, but also for the EU, where sometimes this type of provisions may at least induce the change in the years to come after the agreement is subscribed. So, this is the last part of this presentation. The idea that I want to transmit here is that, well, we know that these treaties, there is not only 1 or 2 or 10, there are many, no? We say that there are 160. This proliferation is giving place to some problems coming from public international law in reality, and the lack of legal development to give adequate response to some of these problems. And the prospects are that this is going to increase. If the Brexit continues, what we will probably see is that the UK will subscribe new free trade agreements, at least with countries such as Australia, the US, India, the big trade partners. No? And obviously, in these trade agreements, you may expect to have an IP chapter. We have as well the ongoing negotiations. It seems that the US has stepped down, then the EU has said, well, we are going to take this place. And the negotiations have given place to new agreements such as Vietnam, Japan and Mexico, recently concluded, and we have these other negotiations that were already mentioned, no, with very big players, no, Mercosur, India, Indonesia, and so on. But also EFTA member states are negotiating nowadays with very large trade partners, and the US, well, the US is now a wall apart, but at least the NAFTA has been negotiated as well, and the IP chapter has also been amended. So, and with important amendments, by the way. So this is going to continue. The bilateralism is going to continue, and this type of proliferation-related problems is also probably something that is going to increase. And what happens when we have more standards adopted by different trade partners? We may expect some clashes, some different standards adopted here and there. Just to put some examples of areas of contention, areas where the United States and the US follow different practices in terms of patentability when it comes to industrial application and utility criterion. In terms of geographical indications and trademark protection, also the principles, the spirit is different. In terms of damages, you will find in US agreements reference to the fact that damages awards have to be deterrent, and eventually in some cases punitive damages are also there, where, as you know very well, in the EU the approach to damages is a compensatory one. And in the area of trademarks, these differences between visually perceptible and non-visually perceptible trademarks. So, just to put you an example, in respect of trademarks, what you have in the same state, and you can say, and Henning knows this very well, if you work with public international law, some will tell there is no conflict here. But if you read these two articles, one says, well, no party shall require as a condition of registration that signs be visually perceptible. This is the US and Colombia agreement. And the Colombia and EU agreement says a party may require as a condition of registration that signs be visually perceptible. You could say, well, there is no conflict here, end of the story. Colombia just follows the US standard, and there is no conflict with the EU one, and end of the story. But the reality is that Colombia, the traditional standard that followed, was precisely the EU one. So they have to change and move to the US standard, something that, by the way, has not yet happened. This type of conflicting, maybe not text, but spirits, start to provoke, to give place to conflicts. Conflicts because of the proliferation of adjudication forums, and now I will explain a particular case that has been litigated, and you will see why this may increase and this may give place to more conflicts in this type. First, these free trade agreements set up new bodies that some occasions have the capacity to oversee, to control the respect of the provisions of the IP chapter. Some of them manage diplomatic dispute settlement mechanisms. And these bodies are called the Joint Committee, the Trade Commission, the IP Rights Subcommittee. They review the progress, the evolution, the level of respect of the treaty and engage in, let's say, friendly discussions. But there are also jurisdictional dispute settlement bodies. In particular, the possibility to request the setting up of an arbitral panel, very much like in the style of the World Trade Organization, with the big difference that this is not a permanent body, but ad hoc body. Okay? So, given that situation, we will have two different possible scenarios. One, that of jurisdictional conflicts. So, conflicts where the same parties, the same measures, and the same substantive violation may happen. But it is even more frequent that other types of conflicts where not the same parties but the same type of rules or the same rules are at stake also happen. And the problem in public international law is that we don't have a clear guidance, or there is a clear guidance but probably it's not enough to give satisfactory answer to this type of situation. Because when the parties to the controversy only partially coincide, at the end of the day, the party will have to choose one or the other treaty, which one will disobey. And this is something that has already manifested. Here you have an example on how a country has faced, let's say, contradictory standards. In Colombia, normally the industrial application standard was the one followed, and still now is the one followed. And this is not by chance. There is a regional agreement with IP regulation. The Indian Community Decision 486 establishes that the patentability standard that will apply in this particular case is industrial application. Then Colombia subscribed with EFTA and also with the EU an agreement that says that you have to respect novelty, industrial application, and inventiveness in order to obtain a patent. So industrial application is there. But later on, the same country subscribes a treaty with the US where everyone understands that utility is the new standard, which is not entirely coincidental with industrial application. What happens? Then the authorities in charge of, let's say, the legal aspects, the normative aspects of IP law, change the patentability guidelines and include utility as a new standard. This is in 2012, but there is a complaint in front of the Court of Justice of the Indian Community, and a first decision comes from the Secretariat of the Indian Court of Justice, deciding that utility is not acceptable in light of that first text. This is Indian Community Decision 486. So, utility is rejected. When utility is rejected, Colombia goes back and says, well, we are going to amend these patentability guidelines, and we are going to be back to the industrial application criterion, and end of story. So we will be, again, in accordance or in line with the free trade agreement with EFTA, the free trade agreement with the EU, and with the regional law. But if the US wanted, the US could raise this issue in the context of the arbitral dispute settlement that has been created, or at least the right to ask for a panel has been recognized in the free trade agreement between Colombia and the US. And eventually, if Colombia was convicted, that probably will be convicted because now it's not following the standard identified in that agreement, we will go back to the previous situation. And if we go back to the previous situation, we will have another dispute settlement body, the arbitral dispute settlement panel, established by virtue of the EFTA agreement, that will rule that it is not any longer the case that industrial application is respected, but utility. Okay? So this type of situation, what has not yet happened is these two, but all this other scenario has already taken place. Okay? In reality, when for instance, in respect of punitive damages, when the US and Colombia agreement says damages have to be deterrent and pre-established damages may have function beyond compensation, when you ask public servants, functionaries working in the government there, they say, well, we are not going to apply this. No? But the violation is already taking place, at least if you take into account the terms of the agreement. So I will finalize this and give up on discussion just to at least to indicate or to identify some hopefully useful ideas to prepare a negotiation on a free trade agreement or IP chapter on a free trade agreement. First, the big difference that you can see from one country to another is when the country has prepared their own views, their own position in respect to different IP topics. Some of them are very complex, are case specific. Someone that knows a lot on genetic resources may not know at all on copyright protection, but countries should prepare their national proposals. And at the same time, there should be impact studies on the effects of these trade agreements. Because what is happening is that countries subscribe agreements without really knowing how much it's going to cost. Very simple things, how much they are going to, they will have to invest in new customs officials or police forces or judicial resources. This type of things are not known. Not to mention the difference between including extension of patent term and not including it. Here in Europe, just to analyze the functioning of the supplementary protection certificate regulation, there has been a very long process of discussion with the studies conducted. This is nothing. I mean, nothing like this happens when negotiating these trade agreements. And it is also important to have this very clear vision on the national and international legal compromises. Sometimes countries negotiate with one country something that is different from what they have just negotiated with a different country. Maybe they cannot oppose, or maybe they just, let's say, do not have yet enforced and are not really aware of what was the real content of the previous agreement. When the negotiation takes place, it is always much better and more productive to have a positive stance, to come with a proposal rather than resisting. And when seeing, observing the negotiators from Brazil, for instance, you can see that there is a real, they know really well what they are doing, and the level of proposals they put forward, the way that they do things is really professional. They always come with something, not with only saying, no, we don't want this, no? Something new. Then this obliges the other party to react, and eventually a middle point can be found. And it's also very important, and this is precisely probably the reason why they sometimes come with some European or US, let's say, advisors, to know the law of the other party. For a Peruvian or, let's say, Caribbean or someone from Korea, a supplementary protection certificate 10 years ago was something that was just unknown. They did not really understand, they could understand, but they did not know what this was about. And the same happens with other areas of IP protection. So knowing what your trade partner is proposing you is also very important. And they have to be prepared for the trade-off. So they may have concluded an IP chapter that is very, very nice, but at the end of the day, the beef quotas or the tariffs on steel or in any other area may just derail everything, and the IP chapter has to be changed, because this is part of a much broader negotiation where all these other aspects are also part. Something that that has been the object of very important effort by Mercosur negotiators is the provision that says that direct application of the IP chapter should not be allowed. The idea is that the direct application of these IP chapters should be something forbidden or put aside, and that it is for national authorities to implement in their national law these IP chapters. And the reason is very simple. Imagine that you may have a judge lost in a small village somewhere that recognizes the direct application of this free trade agreement and a specific interpretation of the free trade agreement without exactly knowing or without knowing very well that area of law. So the same happened in respect to TRIPS agreements and at the EU level, no? Whether countries should be able to, whether judges at the EU level should be able to implement directly the TRIPS, or this should be done differently, no? By means of passing national laws. And two final content points in respect of the free trade agreements. It is very important to include benchmarks. So if these free trade agreements or if these IP chapters in free trade agreements are going to work, no one should be afraid of including provisions saying, well, in 5 years we are going to review this because these objectives that we have identified as very good objectives are going to be assessed in 5 years. This should be there. And again, I will say that this is more technical, but I think that including jurisdictional conflict clauses, saying, well, what happens in case there is an overlap, in case we do not agree, where should we go? This should also be present there. Ideally, with referral to the World Trade Organization dispute settlement system if some mismatch or some lack of agreement appears in the context of a specific controversy. And this is the very last slide, is just more, I would say, something to think about. What you have on the right side, on the slide, in the top, is the perception of the people, let's say the population, in respect of free trade agreements in the US. But I would say that in the EU will be very similar. As you can see, in the US, free trade agreements or free trade is perceived as globally positive only for one thing, for lowering prices. But for the rest of things, let's say when they think about the rights of the workers, when they think about the protection of the environment, and when they think about the quality of the products, trade or free trade is going through a difficult moment. So you have that particular social perception of free trade, and at the same time, in the particular area of IP, the Commission has recognized that, and this is in the text of the 2014 Strategy for the Enforcement of IP Rights, the influence of social perceptions and attitudes towards intellectual property. And it is directly quote, and how these perceptions impact on the derailment of some initiatives aimed at enforcement of intellectual property rights. Obviously, they had in mind ACTA, and probably they have in mind other IP processes. The Commission herself recognizes that there is a perception of overreach by right holders impacting on access. So you have these two trends, no? A trend of skepticism toward the benefits of free trade, as we knew, and a trend of involvement of, let's say, the broader public in the right policy, the right IP policy. Not against IP, but let's say, what type of IP? All in all, this should make us think, and probably the Commission more than us, that it is necessary to explain more, it is necessary to explain better where are the benefits of these IP chapters in trade agreements, and to be more transparent when negotiating these trade agreements, and to give space to modify, to amend these trade agreements. So I think that with this, I can just leave it here and give place to some discussion if there are any questions.
Excellent. Yeah, well, thanks so much.